We welcome everyone to the Court of Appeals of Indiana, the Appeals on Wheels session. The case being presented today before us is Singh versus State of Indiana. My name is Scott Lee. I'm an associate professor of political science here at Indiana University East. I'm the chair of the Department of Criminal Justice and Political Science, and I'm also the pre-law advisor here on campus. So all of you students who are excited about law school, I'm happy to visit with you. We acknowledge and are grateful for the members of the Court of Appeals of Indiana who will be joining us shortly, for their staff, along with our local judges, local and state government officials who are here with us. We acknowledge each of you, our students, staff, faculty, and members of the community. We thank you all for coming. We want to thank the IU East staff that have worked so hard to get everything set up today for this event. Just an aside, we have spots for a few more students to join with the judges after lunch. If you would desire to do that, please just talk to me. I'll get you on the list so we can do that. It's going to be, and that luncheon is in the community room, which is right across from the den here in this building. So before it starts, let's just go over a few housekeeping items. Please, no talking. At the end of the session, there will be a question and answer period, but do not, emphasis, do not ask any questions about the case that is being argued today. When the judges enter the courtroom, enter this auditorium, it becomes in essence the courtroom, and courtroom decorum needs to be observed. So please be respectful of those individuals who have personal involvement in the case. Remember that the parties, their families, and others are people who have been personally affected by these proceedings. Please silence your phones. I've asked the state trooper not to arrest you if your phone goes off, but no guarantees. No pictures may be taken. No recording of the session is allowed. The court staff are recording it, and it will be available for viewing on the court's website. WCTV is also recording it, and it will be available in a couple of weeks on Channel 20. Please remove your hats if you have one on, and then just to make sure that you don't miss the event, once the judges come in the court into the room, the doors close, and we need to remain here until the session is over. There is a case synopsis up on the back table if you didn't see it when you came in. It tells a little bit about the case, along with the three judges that will be here with us today. When the judges enter the courtroom, we will be asked to stand and to remain standing until we're told to be seated. So again, welcome to this session of Appeals on Wheels of the Court of Appeals of Indiana.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Indiana is now in session. The Honorable L. Mark Bailey of Decatur County presiding, with the Honorable Peter R. Foley of Logan County, and the Honorable Dana J. Kenwedy of Grand County.
Good morning. Be seated. Good morning. This case is criminal case Jaspreet Singh versus State of Indiana. It's on appeal from the Case Superior Court. The Indiana Court of Appeals cause number is 23A CR 2453. On behalf of Mr. Singh, Mark Lehman is here. Yes, okay. And on behalf of the State of Indiana is Carolyn Templeton. Mr. Lehman, you've reserved 6 minutes for rebuttal. The case is with you. give us a short rendition. I think the audience has a summary of our cases, but a summary of the case. But if you could give us a short rendition of the facts, we would appreciate it.
Certainly, Your Honor. Good morning, judges. Your Honors, Jaspreet Singh raises two issues on appeal. First, whether he committed a reckless homicide when Jamie Pay struck the back of his truck. Second, whether his aggravated sentence was an abuse of discretion and inappropriate in light of his character and the alleged offense. Around 8:30 in the morning on March 1st, 2021, Jaspreet Singh was driving on US 35 South, which is a 4-lane divided highway. Singh inadvertently slid past his left-hand turn onto US Highway 24 at the Anoka interchange and brought his semi to a stop. Singh activated his flashing red hazard lights as he decided for about 3 to 5 seconds what to do next.
Step back just a minute.
He may have started slowly backing up his truck. That same morning, 24-year-old radiology student Jamie Pay was also driving on US Highway 35 South. Pay was traveling at 75 miles per hour, which was 15 miles over the speed limit. She was speeding in the passing lane. She was not wearing a seatbelt, and she collided with the back of Jaspreet Singh's semi and died instantly at approximately 73 miles per hour. Pay made no attempt to apply her brakes prior to the crash, but was in fact accelerating. Eyewitnesses and the car's data recorder showed no hard attempt to avoid the collision. Pay was straddling 2 lanes when she struck the semi at nearly 75 miles per hour. And a forensic evaluation later showed that she was using Snapchat shortly before the collision. At best, according to the state's own accident reconstructionist, Pay may have seen the semi a mere half second before the collision and started to change her behavior. After the accident, Jaspreet Singh immediately called 911. He cooperated and was interviewed with the police. He traveled repeatedly from California to attend 2 trials in this case. He has led a law-abiding life. He apologized for what happened. Yet the trial court imposed an aggravated sentence, which we argue is inappropriate in light of the facts of this case. Yes, Your Honor.
Was there an intervening superseding instruction provided to the jury in the second trial?
Yes, Your Honor. Yeah. But Your Honor, with regards to that, the case law on intervening cause requires it only comes into effect if there's an actual legal cause between the defendant's conduct and the death. And so intervening cause or superseding cause is only relevant once causation is established. Intervening cause is analogous to proximate cause or the Paulsgraf decision that we hear in law school, which is that there's some unexpected cause that absolves us of liability once causation is already established.
I understand that, but wouldn't you say someone with a semi-truck backing up on the passing lane of a 4-lane highway would at least initially be the causal relationship to the accident itself?
Absolutely not, Your Honor, here. Because the legal issue here is but for his reckless conduct would the events transpire differently. He slid past his intersection. There is very little, if no dispute, that that was an inadvertent act. Had he decided to put that into gear and start moving forward, she still smacks the back of his truck. Had he just decided to wait there 2 seconds longer, she still smacks into the back of his truck.
But he stopped, slowed down, missed the exchange.
Yeah.
And so he is, I think there's a minimum posted speed limit for the divided highway also, right? Or is that only with interstates?
Judge, I don't know the answer to that. The state never presented that as a legal issue, saying that somehow he was violating the law. What we know is he inadvertently missed his stop, which we all do, almost probably once a week.
But isn't the decision of Mr. Singh that is that issue is not the inadvertence of missing the stop, but it's what you do as a result, how he's missed his spot. So his purposeful, he intentionally chose a course of conduct that placed his semi-rig either stopped or backing in the travel portion of a divided 4-lane highway. Is that correct?
I don't think so, Your Honor. I
think
think
where isn't it?
So he slides past and stops inadvertently.
You say slide. Did he
Yes.
skid?
No, I don't think there's no indication of like, I think, tracks where he's braking so hard
Okay.
that screeching past.
And it's dried. Just so we properly characterize the word slide. It wasn't inclement weather. There wasn't snow.
Yeah.
There wasn't something like that.
He
Okay.
inadvertently missed his turn.
Right. Okay.
And so then the question is whether he engaged in conduct that was reckless, which is a plain, conscious, and unjustifiable disregard of the harm that is a substantial deviation from acceptable standards. He had choices here, and look what he did. He turned his flashers on. Oh, shoot. I've done something. I've made an error in judgment. I've made a mistake. I need to protect those behind me. So he turns on his flashers. Then he spends somewhere between 3 to 5 seconds evaluating what is the proper course of conduct going forward. Now, he says you could either go forward, of which you're already in the lane, going very slowly in that rate of travel, or you can back up. We have one witness that says he backs up. No other witness says that, but Mr. Singh says he stopped and was evaluating what to do next when she hit him. So if we find, we would say under no circumstances is the inadvertent missing of your intersection, would that be reckless conduct?
Well, okay, but he can miss his intersection and not be stopped, correct? I've blown a turn and keep going.
Yeah, he could keep going. He could slow down, correct. Yeah, to a point like
you
five.
can not even slow down.
Yeah.
I can just take the next street.
Well, I think he was slowing
Next
down.
left turn.
His testimony was he's slowing down and doesn't reach the
Right.
and then
But
doesn't get it
I'm
slowed
kind
down.
of getting
to
at
make
the
turn.
calculus of decision making.
Yes.
Within that period of time that you characterize as
Yep.
missing a turn and what do I do next? And to me, the elements of causation, proximate cause, emanate from that calculus, not the inadvertence of missing the turn.
So the causation element, if you find that first step that it's reckless, what he did, which is a substantial deviation from acceptable standards, then you reach the next question is, but for that reckless act, would this accident still have occurred? And the answer is absolutely yes. Even if she had seen this vehicle 5 seconds earlier, she wasn't wearing a seatbelt. Even if she had made an attempt to slam on the brakes, which she didn't at all, because she's not even wearing a seatbelt, this accident is fatal probably at 20 miles per hour. His decision tree that he makes in that 3 to 5 seconds, if this court finds that is reckless, and again, we would say that is not a plain, conscious, and unjustifiable disregard or substantial deviation. But even if this court finds that, you have to say that but for that wrong choice of action that he made down that decision tree, she would have lived. And there is nothing in this record that suggests that she would have survived had he made this decision tree differently. The reckless decision tree.
So in your analysis of that, I want to make sure I understand your argument. That goes to then the proximate cause. So the disregard of the decision making, and then there's a probable consequence. What's the natural probable? You're saying, are you saying there's more than one proximate cause in this? There's only one proximate cause. There's no proximate cause.
Causation and proximate cause, or causation and intervening cause, are separate analysis. Causation means my reckless conduct.
Right. So before we even get to the intervening, you're saying
Yeah.
that there's insufficient evidence to support the verdict at this point.
Yes.
Okay.
So if just hypothetically, if someone is firing a gun randomly up into the woods, you say that it seems reckless. Somebody has a heart attack the next day. There's no link there. Here they're saying his reckless act was the backing up, but that had nothing to do with whether this is a fatal accident or not.
The intersection itself, had he identified the turn and didn't blow past the turn,
Yeah.
would he have still been doing 60 miles an hour in order to make that turn?
I think that even if he'd done everything correctly, you're slowing. This is one U.S. highway onto another U.S. highway, and this isn't instantaneous. You're taking a multi-thousand pound semi truck, swinging it from one lane to the other. That could be reckless in itself. This gentleman, step back here, would have been slowing down to get into the turn lane to make a turn from one highway onto the other in that same lane if he was doing everything perfectly.
Was there a turn lane?
There was. There we
So
see
if
a
he
little.
hadn't missed the turn lane,
Pardon?
if he hadn't missed the turn, he would have been in the turn lane rather than the past left lane of the highway.
Pure speculation, Your Honor. That would have assumed that he would have been going 60 miles per hour and then swung into that turn lane. But we all know, and common sense stuff, you are slowing down
Right.
on a 60 mile per hour highway before you can even get into the turn lane. And I think this is where the seatbelt part is relevant in the analysis, is that even if he was slowing down to 50 miles an hour or had reached the speed of 40 miles per hour as he's getting into that turn lane, she's going 73 to 75 and accelerating, and she still hits him. So even if he's at 50 miles per hour, you're looking at a 25 mile per hour collision with a woman who's not wearing a seatbelt. It's fatal, I think, regardless of anything he does. But again, I don't want to dwell too much on what speed he could have theoretically slowed down to before he got into the turn lane, because the relevant issue here is, but for the reckless act, would this still have resulted in death? And the reckless act that the state's alleging here is the backing up, because Tyson Freiberger, one single witness, says, I think he was backing up very slowly. That's the reckless act. You take that out of this equation, worse, this case is still a fatal accident, because he still would be in that lane, either going slowly or completely stopped or trying to accelerate to go up the highway further because of the inadvertent mistake that he made.
Well, your next argument, you did, I assume you were the one that tendered an intervening cause instruction in the second trial.
No, that was trial counsel, Mr. Hershey. Yeah. But yes, you mean my client.
Yeah.
That's it. You're correct, Your Honor.
Okay. So
I think,
I
I don't remember if Singh tendered it or if it was agreed, but in any case, yes.
anyway, there was an instruction. So that's effectively the fallback position, that if it's deemed to have been reckless, still it's about for analysis, and but for his backing up, then were there any intervening, superseding causes that might otherwise have caused him liability, offsets his liability because of the intervening cause, namely the speeding and the diversion from the road with the Snapchat and so forth.
Judge, I see intervening cause as independent and not part of our analysis. And in the reply brief, you say, listen, this isn't an issue
But
of
if-
intervening,
but
it's a
if
but
we-
for cause.
Well, but if we say it was reckless,
It's still, he did not, but for that reckless act, he did not cause the accident. So the line of cases that we cite on the causation issue, like Carter, the Indiana Supreme Court case, deal with, would this collision still have occurred but for the guys in that case drinking a bunch of whiskey?
Right.
They say, yeah, he still would have hit that kid even if he wasn't drunk.
because
If a
of
jury finds
but
cause-
that was because of the child jumping out into the street to retrieve his shoes.
Yes.
And so, so you want to keep us to the but for as far as the initial liability on the part of your client, and not go to intervening cause.
Judge, we think the evidence is insufficient. If the court wants to say that her misconduct, and I'll continue to eat into my rebuttal time here to answer the question, if the court wants to find that he was reckless and he caused the death, I think this court is still free to find on this record that her conduct was an intervening cause or a superseding cause that makes him not criminally culpable, period, full stop. If I see there are multiple shortcomings in this court, in the state's case here, that show that the evidence is insufficient. It's not reckless. Wasn't a but-for cause. her conduct constitutes an intervening cause. Boom, boom, boom. They fail on all three of those regards. I just think that we can cut this off a lot earlier than the intervening clause analysis, Your Honor.
Well, I don't want to cut into any more of your rebuttal, so
Thank you.
thank you, Mr. Lehman. Ms. Templeton? Ms. Templeton, what if this truck was broken down?
So that's a different choice, Your Honor, because that's a different case, Your Honor, because then he hasn't made the conscious choice to stop his 2-ton truck in the left lane of a highway. And that's the problem here. I don't know that the state.
What if he thought he could get to the next gas station and he couldn't, and so he made that decision? What if he decided not to get a tire change before he should have, and for whatever reason, a conscious choice to have a truck break down right there? We've seen that in numerous highways and locations.
Sure. Well, I think it is those situations where there's a flat tire, there's lots of potholes this time of year in Indiana, right? If a flat tire happens, if you run out of gas, that is a lot closer to a poor judgment and an inadvertence than his conscious decision when he realized he could not make a turn to stop. And I would point out that the evidence here, the state's evidence here, is that he wasn't in the turn lane. He's only a little bit past the intersection when his truck comes to a stop, and he was not in the turn lane. So at no point was he trying to make that turn. And to suggest that the only choice he had was to still try to make that turn and for his own convenience back up to make it rather than going down a mile further to turn around is why the state has established that his conduct was reckless. He chose, for his own convenience, when he realized he couldn't make the turn, to stop and back up on the left lane of a divided U.S. highway. And that's reckless. And
What about the but-for? He's reckless, but was it but for his actions that caused this, or was it the speeding, the inattention to driving down the highway? Was it the veering from one lane to another?
so the testimony from the crash reconstructionist, Your Honor, was that those movements were consistent with someone trying to change lanes. So 3 seconds before the crash, Jamie Pay let off her accelerator and then re-accelerated. The crash reconstructionist testified that was consistent with her trying to change lanes and not doing so for some reason. He also testified that where she hit the truck and the position of her car when it came to rest was consistent with her trying to change lanes at the moment of impact. There's also evidence here. The crash reconstructionist on page 228 of transcript volume 2 says her seatbelt did not make a difference in whether this accident was fatal. Her wearing a seatbelt is not a cause of her death, and this court has held on multiple occasions that a victim's failure to wear a seatbelt is not an intervening cause. But for Mr. Singh being stopped or reversing in the left lane of a traveler, there'd be nothing for her to hit. The jury made a reasonable inference here that Mr. Singh's conduct of putting a 20,000-pound truck in a travel lane of a U.S. highway was reckless. And this court has to make all the reasonable inferences that the jury did under the standard of review. And so it cannot second guess that conclusion from the jury.
Does Mr. Singh's training as a CDL driver have any bearing on our decision?
I think so, Your Honor, because I think his training and his own testimony shows he knew how dangerous this was. He testified, first of all, that he tried to slow down and make this turn 20 feet before the turn, which at a highway speed is too short even for a passenger vehicle. He also testified he knew it was dangerous for him to be there. That's why he put on his flashers. He acknowledged that he had 3 other safer options once he realized he missed his turn and decided against those 3 options. All of that, I think, indicates that Mr. Singh knew what he was doing was dangerous, and it is certainly against the acceptable standards of conduct to stop on a travel lane when there's no other reason to do so, like your car breaking down, like some other obstruction, like traffic, like something like that.
Did his conduct violate any state statutes, infractions, or other some kind of CDL or other motor vehicle rules, laws, or regulations?
It did, Your Honor, yes. The state didn't specifically allege it, but when I was reviewing for this argument, it does appear he violated the reckless driving statute, which is Indiana Code 921-852, which also prohibits a person from driving at an unreasonably low rate of speed that endangers safety or property of others or blocks the proper flow of traffic. There's no doubt that driving either 0 miles an hour or -1 mile an hour effectively is an unreasonably low rate of speed in this situation.
Isn't there a statute also for driving on the highways that you're supposed to keep and maintain a proper lookout and operate an automobile at a speed appropriate given the nature and circumstances?
I think so, Your Honor. And arguably he was driving the wrong way. If he was reversing, because the one-way statutes talk about the direction of travel, and on a divided highway, you're supposed to drive on the right-hand roadway in that direction of travel. And he was not doing that because, again, he was reversing.
To Judge Bailey's point, does it make it a difference that she is violating an Indiana statute as well?
It only makes a difference if that violation was an intervening cause, and here they were not. So, first of all, I would like to point out that the cell phone evidence is that a minute and a half before 911 was called, Jamie sent a Snapchat message. That's it. There's no other evidence from which either the jury or this court could conclude that she was on her phone at the time of impact, and a minute and a half at highway speeds is a long distance, right? She might not have even been in view of the semi when she sent the Snapchat messages.
Are you allowed to use your cell phone driving down the highway?
No, you're not, Your Honor. No, and certainly, if Jamie was driving when she used her cell phone, that is a violation of Indiana traffic code. It's also a violation of Indiana traffic code to speed and not wear a seatbelt. But again, one, the crash reconstructionist testified that the seatbelt didn't make a difference, and two, the evidence is a minute and a half before the accident she was on her cell phone. So there's no way for this court.
A minute and a half. She was on her cell phone before a 911 call came in.
Yes.
So
but
a 911, the event had already occurred in order to be making a 911 call. So it was sometime less than 90 seconds.
yes, sometime less, but not a lot less, Your Honor, because the testimony from both Mr. Singh and the other witness who called 911 was that they called immediately after the crash happened. So maybe a few seconds, but certainly at least a minute before the accident was.
How far can a car travel in the time of 1 minute doing 75 miles an hour?
It would be a little bit over a mile.
And was that a fact in the record?
Yes.
Is that part of the reconstructionist testimony? Or at least some experts' testimony?
How far she could have traveled in a minute, Your Honor?
Right.
Or,
Extrapolating attaching a distance to that time interval.
I don't think so. I think the prosecutor in his closing argument asked the jury to use its common sense when he was talking about the timing of the Snapchat messages and the 911 calls.
Okay.
I don't think there was specific expert testimony. There was testimony from the off-duty trooper who was a witness to this, that there was an exit or an entrance onto US 35 about a mile and a half before the Anoka exchange where the accident happened.
What about the defendant's argument that we don't even need to get to intervening, superseding cause, that if recklessness can only be determined by looking at the causal connection, that for this truck stopped on the highway for whatever reason, would the event nevertheless have occurred?
So the but-for causation looks at if the truck wasn't there, if the truck wasn't stopped, would there still have been an accident? And I don't think that there's any support in the record for that conclusion, because again, if Mr. Singh had made his turn, he wouldn't have been in the travel lane. He would have been in the turn lane or have turned. And so there's no support that this accident would not have occurred if Mr. Singh had done everything perfectly, because if he had done everything perfectly, he would have made the turn and not been in the same lane of travel as Jamie was. And so I think the state's evidence more than amply proves that Singh's decision to park and reverse his semi in the lane of travel was a but-for cause. And there is no evidence that Jamie was herself an intervening cause, because her behavior isn't so extraordinary that it is unfair to hold him responsible for his own choices.
Well, I would hope it is extraordinary when there are three statutory violations that we're talking about. Are you suggesting as a state that people can disregard traffic rules and regulations, that they can use their cell phones, that they can exceed the posted speed limit, they can keep and maintain or avoid keeping and maintaining a proper lookout?
Of course not. Of course not, Your Honor.
So it may not be as so. To suggest that, and I saw in your brief as well, I think it's less than appropriate that the state, of all people, should be arguing that that these violations should be overlooked and disregarded.
What I am suggesting, and what I tried to argue in my brief, Your Honor, is that no matter how much these are violations of the traffic code, this court has been clear that not wearing a seatbelt is not an intervening cause. The court found that in Cannon, I think, most recently.
I think not wearing a seatbelt, you have to have another primary violation before you can even get to the seatbelt violation. Anyway.
But I think, and this court has also sort of acknowledged in the other reckless homicide cases with a vehicle that minor traffic infractions will not support a reckless homicide conviction in those circumstances. And I know they're not exactly the same, but I think the same logic applies, is that, well, we certainly do not condone violations of the traffic code, especially sort of more dangerous violations of the traffic code. They are foreseeable. People speed. I drove here on 70. People sped past me. I got passed a couple of times, right?
But you left early enough that you didn't.
I did. But my point is, Your Honor, is that it is not unforeseeable that people speed, and that is what is required for the conduct to be an intervening cause. It has to be unforeseeable. It has to be so sort of unexpected that it is no longer fair to hold the defendant responsible for his conduct.
Can it be unexpected that a car would break down, hit a chuck hole? I mean, that's the reason for the statute to keep and maintain a proper lookout.
Yes, Your Honor, and that is unexpected. And maybe if Mr. Singh's semi-truck had broken down, he wouldn't have been charged. I think that's a different circumstance than what we have here. And that is a reason why we do want drivers to be paying attention and not be on their phones.
Well, isn't it just as foreseeable that people occasionally might miss their turn as well? And that's the reason for the statute to keep and maintain a proper lookout.
Missing a turn is foreseeable. Stopping and reversing is not. And I think that's the distinction.
Well, I think looking at the intervening cause, I think the point is that it is foreseeable, is it not, that there's some obstruction in your travel lane, and that you have to maintain either all those variables, your attention, your speed, your lookout, and off your cell phone in order to readily observe those things in enough time to take defensive action. And I think as I understand the argument is that but for those things, the accident wouldn't occur.
So first, Your Honor, again, there is no evidence that Jamie was on her cell phone at the moment of impact. She was on her cell phone. The only thing we know is she was on her cell phone a minute before.
Okay.
And so I think we should take that out of the equation. So the question then is speeding and not wearing a seatbelt an intervening cause? The crash reconstructionist told us the seatbelt wasn't. He told us it still would have been fatal even if she had been wearing her seatbelt.
Well, let me break into that. Take away the speed. Say she was going the speed limit and there's no deflection from her driving, so no off the accelerator, and it's just a straight square collision with that truck. Does that change the analysis? Because to me, it gets to the heart of proper lookout rather than these other things.
Sure. So one thing I will say is causation is a very fact-sensitive inquiry. These are usually questions of fact left for the jury to decide. In my research, I was not able to find a case where this court has found an intervening cause. So it's sort of difficult to know where those boundaries are. And that might be a closer question of fact for the jury to resolve. And certainly I think if this is a completely different case and we have somebody who not only doesn't vary, but maybe accelerates into the back of the truck, and it starts to look more knowing and intentional rather than the result of negligence. I think that's a different case. That's not what we have here, though. We have a case where a driver was speeding and wasn't wearing her seatbelt, tried to avoid the collision, and was unable to do so.
We don't have evidence that she tried to avoid, other than the accident reconstruction said that it looked like possibly as it tried to turn the wheel, but it was a fraction of a second.
So there are two spots, again, where the crash reconstruction said there might have been an attempt to turn, but that is a reasonable inference the jury could have made from that testimony, that she was trying to change lanes and didn't for some reason or another.
And as counsel, just want to go back to a point that I think was made with Mr. Singh's counsel, was there is no allegation of error with respect to jury instructions in this case. Is that correct?
That is correct. There is not.
And the jury did get a superseding intervening instruction the second time around.
It did, yes.
So to your point, it may be a factual determination by the jury.
Yes.
Does the state have a response today regarding the sentencing argument?
In the state's view, the trial court did not abuse its discretion and the sentence is not inappropriate. With respect to the trial court's, the claim that the trial court abused its discretion, the trial court found that Singh's lack of remorse, late showing of remorse, what was an aggravating factor. The lack of remorse aggravator is appropriate when the defendant exhibits disdain or recalcitrance, the sort of like saying, I don't care versus I didn't do it. So there does have to be a distinction between just maintaining his innocence and I don't care, I think. And here, the trial court appropriately found that the defendant's preoccupation with himself and how this accident affected him, and a lack of understanding about his role in the accident was an aggravating factor. At the scene of the accident, after learning that the driver of the other car was dead, his only question was about when he could get his truck back and when he could leave. Even at the second sentencing hearing, when he gave a statement and nominally apologized to Jamie's family, he said, I don't understand how this happened. I never thought this would happen to me.
Well, let me go back. The trial court's finding was that his remorse at sentencing hearing was sincere. That was a specific, explicit finding of the trial court, was it not?
I don't remember, Your Honor, but I trust your reading of the record.
Okay, so what I find problematic is disentangling the timing of remorse as an aggravating factor, and that at roadside, and then we also have culture and maybe religious beliefs in the stoicism raised by the defense of the Sikh culture and religion, that and holding somebody in a roadside in a very traumatic, kind of chaotic place rather than at sentencing hearing. It's problematic to me if we would affirm that we've got an issue where we're affirming the idea that there's this timing of remorse matters when and you get over those explicit finding of the trial court. So walk me through how does that work? How am I jumbled up in the wrong place?
Sure. So acknowledging sort of the distinction between at the time of the incident versus later points. I would also point out that at trial, his testimony was similar, right? He was in shock for myself as to how or why this accident happened, is what he says at trial when he is asked how he learns. And that's, I think the second trial was a couple of years after the accident. And that is consistent with not only what he said at the scene, but then also what he says again at sentencing. And so we sort of have this repetition of his recalcitrance to understand his role in the accident. Whether or not he thinks he's guilty of reckless homicide, he stopped his truck and she hit him, right? He played a role in this accident regardless of his own belief about his his innocence. And so, I think that's how the court can separate it from just maintaining his innocence. But I think it's also why his commentary, his comments support a lack of remorse aggravator.
What was there was trial 1 and then trial 2, which we have the appeal today from. Trial 1, what was the sentence?
6 years. It was the maximum for a level 5 felony. And the trial court lowered that by 2 years to his 4-year sentence in this case. And if there are no further questions, the state respectfully requests that this court affirm the trial court. Thank you.
Thank you, Ms. Cooper. Mr. Lehman, is there any way to turn the microphone down just a little bit? Because we keep getting feedback. Thanks. Give it a try. Mr. Lehman, before you start with your rebuttal, I'll ask you a question. So you won't concede, but nevertheless, parking in the passing lane of the 4-lane highway and possibly backing up could be viewed as reckless. Don't you agree?
I agree the state charged it because they felt they had probable cause based on the facts.
So you're telling me that in just the normal scheme of things, you wouldn't consider that to be reckless, parking the truck and then backing it up?
I don't think parking a truck is different than what happened. That's the word parking as you're using it, Your Honor, sounds like a plain and conscious decision. That's, I'm going to park right here. And the devil may do what happens.
The plain and conscious decision then is to stop the truck, put the flashers on, and slowly start backing up. But before you back up, the car, the vehicle is stopped. So whether you're parking it, that you can park, or have your foot on the brake before you decide to choose what you want to do next, and that might be go down the road a mile and get in the next turn lane and turn and come back and get the exchange that you wanted, or whether you want to try to shorten your trip and back up on a 4-lane traveled highway and the passing lane. I understand your argument, but I can also understand that maybe somebody might consider that reckless.
It doesn't meet the definition of reckless because as you described it, it's got to be a disregard of the harm. We all make mistakes. The question is do we disregard the lives of others once we realize we've made a mistake? As the difference between parking and not turning those lights on and saying, let's see what happens, is different. That's an unconscionable, unjustifiable disregard of risk versus what you just described that Mr. Singh did, which is, oh, I missed my intersection. What do I do next? Well, first off, I put my flashers on so that people behind me, if they're keeping a proper lookout, will see me. Now, I have a choice to make. Do I try and get this thing into gear and get going? Do I try and switch lanes? Do I try and back up? I have made an inadvertent mistake because I'm tired, I'm driving a long distance, I've just dropped off my load. Recklessness is, I don't care what happens. That's parking. That's being a jerk. That's sitting there and saying, maybe someone will smash into the back of me. This was not a plain, conscious, unjustifiable disregard and a substantial deviation from acceptable standards. When people drive past intersections, acceptable standard is, I've got to care for those around me. First thing, hit the emergency. Second thing, evaluate my choices and do it quickly within 3 to 5 seconds and make the decision that I think is best under the circumstances.
What if he would have decided at that point he missed his stop?
Yep.
And so instead of trying to back up, the vehicle was in stationary position for a couple of seconds. Started to fire back up and head on to the next exchange. How fast would he have been going at that point?
He said the only testimony we have is these things take a while to get going. Right. And we still have a fatal accident. Right. No matter what choice he makes, we have a fatal accident. And the state is incorrectly construes the record when they say the issue of causation is whether his truck was there or magically wasn't there. No. The statute says a person who recklessly kills another human. Is the reckless act the thing that killed you? The reckless act that the state has to say is the reckless act is the backing up. Because it's not parking. He didn't park. He missed his intersection. Then he put those lights on to try and evaluate how to solve his inadvertent error. No one disputes that this was an inadvertent error that got him in this spot. The question is how he handled the inadvertent error. Was that reckless? And two, had he chosen to handle it differently, would this accident still have occurred? How he handled it wasn't reckless, and how he chose to handle his inadvertent mistake wasn't reckless, and had he handled it differently, Jamie Pay is still deceased. And that to us is the analysis there.
Won't be pulled forward even at a slope. She may have avoided it.
There is zero evidence to that.
I guess where I may see a distinction is not just what he did after he stopped, but the decision of coming to a stop in the travel lane, the left-hand lane. Because there's time lag between when he knew he wasn't going to make his turn, because the photographs we have it's past the turn, and it's not as if he's on the berm and blew into the median because he couldn't make his turn. There was a conscious choice before that to stay in that left-hand lane and then just continue slowing after the turn to come to the stop. Is my analysis flawed or not supported?
So I don't know how much of that is in the record. So I see the judge is drawing the dots there as to what his decision tree is in that moment. And we're not truck drivers, and theoretically, I say maybe they can pull over to the side, maybe try and switch lanes. He's got a lot of decisions that are occurring there. But one thing that's not occurring is an unjustifiable disregard of the lives of others on that highway. He's thinking about those, and he's making a decision tree. That's what the difference between what we have here and the cases that Whitaker goes through and summarizes where they did find reckless disregard. Guy turns his lights off and just starts driving at night. Guy starts boozing and driving through intersections. Let's see what happens. Crazy. Scare my girlfriend. Well, that kind of stuff.
One thing that struck me maybe, and tell me where it meets up or doesn't meet up. Is this not more analogous to somebody who's coming up on I was trained as a stale green light, and instead of slowing, hits the accelerator. So I've made a decision, and then I go through on red, and I may have the conscious choice. Well, others should be able to see me, and shouldn't be look both ways before they start out of their green light, and I collide with someone.
Yes,
I mean, where's that analogy flaw?
I think that's a Whitaker type situation where this court said that's not reckless homicide. The guy went through he hit someone in the back because he was keeping a close enough distance. He smacked the back up and pushed him into an intersection of a car. He said, in Whitaker, that's not reckless disregard.
But my analogy is a conscious choice to hit accelerator at the yellow rather than brake.
So I think, again, all the facts and circumstances matter. It says that plain, conscious, unjustifiable disregard and substantial deviation. I don't know if he's trying to make it a yellow, if that's a substantial deviation from normal conduct. Thank you, Your Honor.
Thank you, Mr. Lehman. Thanks, Mr. Templeton. Commend the counsel for their admirable arguments here today. Take nothing by way of our questions, but we only make the inquiries to help further our discussions once we adjourn here and begin our deliberations in preparation of the written opinion in this case. Typically, we would step away and begin our deliberations, but because we're here at IU East here in Richmond, Indiana, we'll adjourn the proceeding and then take questions from the audience about anything we're talking about other than what we just talked about in the last half hour. Okay? Can't talk about this case. With that, we're adjourned.